Honorable Mr. Justice Vincent Morrison presiding, Mr. George Dangerfield acting for the Crown, and Mr. Robert Carter acting for the defense.
Are we ready to proceed, gentlemen? Mr. Carter, I believe you're first.
May it please your lordship. Ladies and gentlemen of the jury, we've now reached this stage of the trial where it is my privilege as well as my duty to address you on behalf of the accused, Mr. Jacobs. As his lordship will tell you during the course of what he has to say to you, each of us here have our respective functions to perform. His lordship will tell you, no doubt, his duty is to preside over this trial, deal with all questions of law, and explain the law to you and how it applies to the facts of this particular case. It's my friend's duty to present the case to you from the point of view of the Crown. Up till now, he has done that. I'm sure he'll continue. Quite frankly, it's my duty to present the case to you from the point of view of Mr. Jacobs. His lordship will tell you that your duty is to find the facts in this case, to deal with all the evidence, decide what the facts are, and of course that most important fact, whether or not the Crown has proved beyond a reasonable doubt that the accused is guilty of any offense. During the course of what I have to say, and in order to explain my position to you, I might be permitted to deal with a few basic principles of law. However, when I do, if what I say in any way differs from what his lordship says the law is, then please disregard entirely what I have said and accept the law as his lordship gives it to you. Also, during the course of what I have to say, it will be necessary, obviously, to refer to the evidence. When I do, if my reference to the evidence in any way differs from your own recollection of what the evidence was, then disregard what I say, rely on your own collective references. You may be sure that I'm not trying to mislead you, but that I have made a note, and perhaps my note's wrong. So if what I say differs from your own recollection, then rely on your own recollections. The principles of law that I propose to deal with, I'm sure you're all familiar with. But I propose to start with some of the basic principles and ask you to approach this case in the light of those principles. We all know that you don't look at this man sitting in the prisoner's dock and say to yourselves, is he innocent? Is he guilty? You look at him and you say, I presume that he's innocent. And then you don't look to him to see whether or not he has proved anything in this trial at all. You look to the Crown. The burden throughout the Crown throughout the trial is on the Crown. What is that burden? If you were suing your neighbor or some other person in a civil action, you bring that action to court, and the obligation would be on you to prove on what we lawyers call a balance of probabilities. That is your case more probable than your opponent's case? But when the liberty of the subject is at stake, that's not good enough. The Crown cannot rely on probabilities. The Crown has to prove its case beyond a reasonable doubt. I'm sure his lordship will define that for you when he comes to address you. In addition, there's one other thing I'd like to say about this case. I know that none of you would be biased or prejudiced simply because the accused belonged to a motorcycle gang. Consciously, I know that wouldn't play any part in this case. But I ask you just to remind yourselves at the outset, so that subconsciously it won't play any part. Remind yourself that you cannot be biased against the accused. And to be fair, you can't be biased against Mr. Hansen simply because he made his living selling liquor to persons who probably, in some cases, were alcoholics and couldn't help themselves from buying it. And certainly to minors. I ask you not to be prejudiced against Mr. Hansen either. Now, in this case, there are two counts. The first count is manslaughter. That is, unlawfully causing the death of William Hansen by means of a blow or blows. Second count is what we call wounding, and really includes two counts. That is, unlawfully, with intent to wound William Hansen, cause bodily harm to William Hansen. And his lordship will explain to you that there are really, in that count, two charges. Count of wounding, the necessary intention to wound, and a count of causing bodily harm if there is some doubt about an intention to wound. With respect to the first count, there are really only a couple of issues that you have to determine. First of all, has the Crown proved beyond a reasonable doubt that blows administered by Mr. Jacobs caused the death of William Hansen? That's the first issue. If you are satisfied beyond a reasonable doubt that they did, then you have to examine the evidence and the blows to determine whether or not those blows that did cause the death were struck in self-defense. If they were, that's the end of the matter. I've said you have to examine them to determine whether or not they were struck in self-defense. That's really not quite accurate. What you have to do is look to the evidence to see whether or not the Crown has proved beyond a reasonable doubt that they were not struck in self-defense. With respect to the second count, as I've already said, first thing you have to determine is whether or not the Crown has proved beyond a reasonable doubt that Mr. Jacobs had an intention to wound. If he didn't, then obviously that count has not been made out. You also have to look to the evidence with respect to self-defense here as well, and to the evidence with respect to drunkenness, and I'll be dealing with this later, and whether or not there was an intention to wound as a result of a combination of drunkenness and all of the circumstances surrounding this unfortunate event. With respect to the included charge of unlawfully causing bodily harm, the issue there will be the issue of self-defense and whether or not the Crown has proved beyond a reasonable doubt that the accused intended to cause bodily harm. Excuse me. Let's go back now to the first count. I suggest to you that the Crown has failed to prove beyond a reasonable doubt that the blows administered by Mr. Jacobs caused the death. You heard the evidence of the pathologist, and you heard that he, when Crown put to him, asked him whether or not his findings were consistent with blows, kicks being administered by Mr. Jacobs to Mr. Hansen, and he indicated that his findings were consistent with that. But he also said that they were consistent with other things. You'll recall that there were really two injuries to the brain which he said contributed to the death. Firstly, there was the deeper hemorrhage down in the base of the brain, which he said wasn't caused by any blows, but had been there for some period of time and had been leaking into the brain. And ultimately, that burst, and that contributed to his death. It's clear that had nothing to do with Mr. Jacobs. And the other injury, the subdural hemorrhage, which was up on the top, on the side of the brain, as I understood his evidence. The question is whether or not Mr. Jacobs, or whether or not the Crown has proved beyond a reasonable doubt that Mr. Jacobs caused that injury. You'll recall the evidence that when Mr. Hansen first approached Mr. Jacobs, as they were sitting in the bar, the altercation developed. Mr. Hansen was pushed onto one person's lap, and he then pushed him off. May well be, and I suggest to you that it did happen, that he struck his head then, and that caused that subdural hemorrhage. Because you'll recall, he didn't seem to be dazed, or nobody said he was dazed prior to that. But you'll recall the evidence that after he got up, he appeared to be dazed. And I suggest to you that that's the time when he sustained the injury. And it could go on for a little period of time. It would take some time for that hematoma to develop to such an extent that it would cause his death. And then he goes outside into the lounge, and he has the altercation with his wife, and his wife slaps him. And then he goes back and he hits his head against the wall. You recall, it was probably the injury to the back of his head. Did it happen when he hit the floor, or did it happen when he hit the wall? We don't know. But I suggest to you, because of those possibilities, you can't find beyond a reasonable doubt that anything that Mr. Jacobs did caused the death. If I'm wrong, if you are satisfied beyond a reasonable doubt that the injury did not happen on either of those two occasions, we then come to what happened. Were the injuries sustained while Mr. Jacobs was defending himself? And was he defending himself? Let's look at the facts that just are not in question at all. Was Mr. Jacobs acting in self-defense, or to put it properly, has the Crown proved beyond a reasonable doubt that he was not? Well, we know that Hansen had a reputation, a bad reputation for violence. We know that he had already beaten up one other person and so deserved that reputation. We know that he hated persons who belonged to motorcycle gangs. We know that he was in a terrible rage that night. We know that he was drunk. We know that he armed himself with some kind of a weapon. We know that he attacked Mr. Jacobs and stabbed him in the back. True, it wasn't a serious injury, fortunately for Mr. Jacobs. You know, I suggest to you that if it hadn't been for the fact that Mr. Jacobs was wearing that leather jacket, it would be Mr. Hansen who'd be in the dock, and Mr. Jacobs who'd be where Mr. Hansen is now. However, let's go on. We know that after he armed himself with a knife, stabbed Mr. Jacobs in the back, he was disarmed. He didn't stop there. He picked up another weapon. He picked up a chair, and he tried to strike Mr. Jacobs with the chair. Now, under all those circumstances, Mr. Jacobs knew all of the things that we knew. He knew about the reputation. He knew about the hate for motorcycle gangs. He knew about the terrible rage he was there and saw. He knew that he was drunk, and Mr. Jacobs had been drinking himself, and so perhaps his judgment might have been a little clouded. But he knew that Hansen was drunk. He knew that Hansen had armed himself with a weapon because he felt it in his back. He knew that he'd been attacked and stabbed in the back. He knew all these things, and I suggest to you that the only sensible thing that a man could do when attacked in that fashion by a person like that is defend himself. Obviously, you're entitled to defend yourself from a drunk who's in a rage, attacking you in a cowardly manner by stabbing you in the back. What would any one of you do if you were attacked in that fashion? I suggest any one of us would do whatever they had to do to disarm that man, to put him out of commission. How do we know what he would pick up next? We picked up a knife for what's said to be a letter opener, sharp enough to go through a leather jacket right into the skin. When he loses that, he picks up a chair. If you don't stop him then, what'll he pick up next? Where'll he go? Come back with what? Perhaps a gun? If he did, what chance? What chance would Mr. Jacobs have at all? Of course, he's got to stop him, and stop him he did. And I suggest that either any of you would have done precisely the same thing. Now, we've spent some days here examining this case. It's all well and good to sit here in the white light, the courtroom, with 20/20 vision, examining all these circumstances. But that's not the opportunity that Mr. Jacobs had. He had to react quickly, in a split second, to defend himself from a cowardly attack. I suggest to you that we should be looking at what happened in those split seconds from Mr. Jacobs' point of view, and not here examining them point by point as though they were under a microscope. I suggest to you that the Crown has failed to prove that Mr. Jacobs was not acting in self-defense. And if you come to that conclusion, and I suggest that you will, then that's the end of the matter, and he ought to be acquitted. There was a great deal of evidence called. A lot of evidence from persons who were familiar with Mr. Hansen over the years, a lot of persons who were familiar with Mr. Jacobs. But I asked you, sit down, look at it from Mr. Jacobs' point of view. He was the person who was attacked. He was the person who had to defend himself. With respect to the second count, wounding and causing bodily harm, the issue really is the same. One thing that I ought to say to you about drunkenness. A lot of the witnesses who are friends of Mr. Jacobs, who are friends of Mr. Hansen, described Mr. Jacobs as being drunk. And you'll recall the evidence that when he went over to the table to sit down with the two young ladies, he either passed out or fell asleep. I suggest to you that indicates that he had consumed a considerable quantity of alcohol. We don't have any concrete evidence. Mr. Jacobs, he gave evidence as to what he'd consumed that day and night. But he wasn't in a position to take any blood from himself so that it could be tested. He wasn't in a position to administer any breathalyzer test. The police were. They were very careful to take blood samples from Mr. Hansen, and they took blood samples from Mr. Jacobs the next day to determine what blood type he was. In view of the evidence that was given I suggest to you it's not fair to Mr. Jacobs to find against him on this issue of whether or not he was so drunk that he couldn't form an intention to wound, when the police had the opportunity to determine beyond doubt what his blood alcohol level was, and they didn't do one single thing to test it. Now, with respect to the third charge, the unlawfully causing bodily harm, His Lordship will define what is meant by that, and indeed all of the charges. And I don't propose to transgress on His Lordship's function by defining manslaughter, wounding, assault, which causes bodily harm. He will deal with it. I ask you, though, the central issue is what was in Mr. Jacobs' mind on that night when he was attacked from the back. Mr. Jacobs, you saw. He said, night in question, the police didn't want to listen to what he had to say. But you recall that when they did record anything that he had to say, he said he'd been attacked and he was acting in self-defense. He chose you to listen to what he had to say. Not only did he choose you, but he is the only person in this world who could make the decision as to whether or not he was going to give evidence. And he decided that he was, and he did. And he asked you to listen and not treat him the way the authorities did that night. You saw him in the witness box. Say one thing for him. You saw the way he was dressed. You saw his general appearance. You saw the way he talked. You saw the way he acted. I suggest to you that he was sincere. He was himself. He didn't come here in a three-piece suit. He didn't shave off his beard. He didn't talk with $100 words. He told you in his own words, in his own manner, precisely what happened. And his decision to give evidence, to tell you what happened, to tell his side of the story, if you like, has two serious consequences. The issue of self-defense was always there in the evidence. It wasn't necessary for him to give evidence to establish that, but he chose to, and the first consequence of that is that he was cross-examined by a very, very skilled cross-examiner. In a rigorous and vigorous cross-examination, you saw it, was no match. You had a man on the one hand, a lawyer of a considerable experience, cross-examining this poor individual with a minimum education. It was no match at all. But he never changed. He never varied from the fact, the essential fact, that he was acting in self-defense. The other serious consequence that his decision to give evidence has is that because of that, because the defense in this case called evidence, I have to address you first. The Crown gets the opportunity to hear what I say, and then has the opportunity to attempt to persuade you that what I've said is wrong. He has that advantage. I don't have the similar right to hear what he says and then attempt to show you why that's wrong. In addition, when I sit down, I know that there are going to be things that I intended to say, but I forgot. So in each of those two cases, the Crown says something that I haven't anticipated. I ask each and every one of you to think of the answer for me and put it forward in your jury room on my behalf. And if something occurs to you that I haven't said, I ask each and every one of you to put forward that argument on behalf of Mr. Jacobs in your jury room. Let no man be convicted of any offense on a failure of my part to think of something or on a failure of my part to anticipate something. You act for me in the jury room. His Lordship will tell you that you are not responsible for the consequences of your verdict, and there can be no doubt about that. You are not responsible for the consequences, but you are responsible for the verdict itself. The verdict is yours. You and you alone are responsible for that verdict. In the coming days, weeks, months, even perhaps years, you will reflect on this case. You will think about it. And when you do, if you have found this man guilty of any offense, and if you say to yourself, gee, I think I was right, or I hope I was right, or even, well, I was probably right, a grave miscarriage will have occurred that can very rarely, if ever, be set right. I leave this case with you confident that that will not occur, and confident that you will return a verdict of not guilty on both counts.
May it please you, my Lord, ladies and gentlemen. The Crown's position in this case is a simple one. We say that there was a beating up on August 14th, 1980, administered by Jacobs to Mr. Hansen, and in the result, Hansen died. Now, before I get to the case itself, I'd like to make 3 preliminary observations. First of all, I'm not going to discuss all of the evidence with you, because that would take too long. But you are responsible to consider all of the evidence, and all of it is important, and you must look at it when you come to make your decision. Secondly, I'd like to caution you that nothing I tell you is evidence itself. You must not take anything I say as evidence. You must rely solely on the evidence you've heard from the witnesses. And lastly, it is no part of my case that Jacobs meant to kill Hansen. I'm sure that on August 14th, 1980, the furthest thing from Jacobs' mind was Hansen's death. Nevertheless, I submit to you that when you have considered all of the evidence, you will be driven inexorably to the conclusion that because Jacobs beat Hansen up so severely, Hansen died. Now, in order to properly understand the evidence, I think, you must view it from 2 points of view. You must ask yourselves 2 questions. Whether anything that Jacobs did caused Hansen's death, and whether the prisoner was justified in doing what he did, irrespective of whether Hansen died. Now, on the first point, I'd like you to consider the medical evidence. It's complicated, or appears to be. We talk about subdural hematoma, subarachnoid hemorrhaging, vascular dilation, blood pressure, and all of that. But relate the medical evidence to the fact situation in which Hansen found himself that night. You will remember that up until the time Jacobs beat him, knocked him to the floor, beat him, and kicked him while he was lying there, Hansen had been getting along all right. He'd been walking around, he'd been dealing with customers, he'd spoken and argued and fought with his wife, and he had had a preliminary argument with Jacobs. Remember also in the medical evidence that the doctor told you that neither one of the hemorrhaging, of the injuries to the brain would have brought about death by itself. If that is to say, that neither of them by themselves would have caused Hansen's death that night. It was the combination of the two that did it, and I submit to you that combination arose when Jacobs beat Hansen. On the other point, justification, as my friend has told you, this raises the defense of self-defense. And like my friend, I am going to have to trespass a bit on his lordship's prerogative with respect to the law. And if I tell you anything that differs from what his lordship will tell you, you must of course accept his lordship's view. But self-defense is a defense that arises from necessity. There must be a reason for doing what the accused is said to have done. And that necessity is a real fear that he will either be killed or suffer grievous bodily harm as a result of the attack he is defending himself against. Was there any necessity of that kind in this case here? I suggest not. Now, it's undoubtedly true that Hansen enjoyed the reputation of being, to put it in the colloquial way, a tough guy. He'd been in fights before, and in fact, you heard Jacobs tell you that he was aware that Hansen had almost beaten a man to death. He was a man who had an abiding hatred for bikers. He was a man who was drunk that evening and was behaving violently in that evening. He had already had an argument with Jacobs. He had already challenged Jacobs and had already been in a slight altercation with him. Isn't it strange that when that first altercation ended and Hansen picked himself up off the floor and turned to Jacobs and said, "I'm going to get you," that Jacobs just sat in his chair and continued to drink his beer? Why did he sit there? Because he had nothing to fear from this man. He recognized him from what he was, an elderly, drunken, loud, boisterous man. Besides, Jacobs was sitting with his friends. He had Pepper on one side of him, another man on the other side, and 2 or 3 around the table on the opposite side. So he had absolutely nothing to fear. Then Hansen came back into the room carrying what turned out to be a letter opener. Now that's a pretty fearsome weapon. Here's this drunken man intent upon inflicting an injury which could cause Jacob's death, and what does he pick up? A letter opener, a flimsy piece of tin used to open letters, not to stab people to death, and he's going to use this to attack a man wearing a leather jacket. Jacobs had absolutely nothing to fear from this man Hansen. But even if he did, even if he felt that sharp stab between the shoulders, as he says he did, and stood in mortal fear, looking around to defend himself, did he cry out for help? Did he shout to Pepper, "This man's trying to kill me"? No, he set about Hansen right off the bat, pushed him over a chair after he'd disarmed him, and proceeded to beat him systematically on the floor, picking his head up, driving it into the floor, hitting his face hard enough to bounce his head on the floor. And when Hansen was absolutely helpless, hands up, trying to protect himself, he stood and kicked Hansen at least 3 times. It was when he looked down on the floor and saw what he'd accomplished, and when they pulled Hansen into the chair and Jacobs observed the blood running from his nose and mouth, that's when he called for help. "Call the police," he said. "This man tried to kill me." I suggest to you, ladies and gentlemen, that Jacobs wasn't frightened of Hansen at all. He was annoyed, he was angry, he was upset, and he took that anger out on Hansen and killed him. Now, ladies and gentlemen, As I said when I started, this is a simple case of manslaughter arising from a callous beating up. The motivating force behind this case is pride, Jacob's pride in his position. He was a biker. He was proud of that. He wore the emblem on his jacket. He had it tattooed on his back. He was proud of the fact he was a biker. And to use his words, he says, "No one messes with bikers." And that's precisely what Hansen had done. Hansen had offended that pride. And in order to remedy the insult, Jacobs beat him to death. Thank you. Lord.
Mr. Foreman and members of the jury, all of the references made by counsel to the instructions that I would be giving you, consider them as having been given.
Court stands recessed for 15 minutes.
For those